Hi everyone, this is Sarah Hobson with Hobson & Hobson PC. We are a family law firm. We protect parental rights and fight for fair financial futures during divorce. And I have with me here my friend Kim Fry. Kim, would you introduce yourself?
I'm Kim Kahili Fry of the Fry Law Group. We protect you when the government tries to jail you. We have an exclusive criminal defense firm here in Cobb County.
So Kim is here. I'm actually in Kim's office, and you can see some of her victories behind us. But there was a really big Supreme Court decision, Georgia Supreme Court decision, that came down on Friday of last week. And I've been begging Kim to please let me interview her about it. I have so many questions. And Kim is kind of an expert in this area, and she's an expert in this area, so I wanted to pick her brain and see how this ruling is going to affect anyone who's been charged with a DUI. Currently, what happened, what about people who have already been convicted of a DUI in light of this new ruling, and so we'll just jump in. So Kim, so the case that I'm referring to is Elliott v. State. And would you just give like a brief description about the ruling in that case?
Yes, it was actually, Mrs. Elliott was represented by my good friend Greg Willis, and he took it all the way to the Supreme Court because he knew he'd be right, and he was. He called it black letter law, essentially. So what happened is she was arrested for DUI and then asked under the implied consent notice whether she would take the state-administered breath test. She said no. She refused. Under our current implied consent, it says if you refuse, you'll lose your license for a year, and that refusal could be used against you in a court of law as evidence in a court of law. What the Supreme Court did on Monday when they issued a 94-page opinion was basically say you have a right to not incriminate yourself under paragraph 16 of the Georgia Constitution, which is actually more expansive than the Fifth Amendment to the United States Constitution. You have the right to refuse, and Georgia law protects you from that going in front of a jury.
Okay, so what you're saying is the Constitution in Georgia actually affords citizens more rights than federal law.
Yes, it's more expansive because it protects acts, not just testimony, not just words. And the Supreme Court in Georgia has said that blowing into a breath machine is an act that cannot be compelled if you don't want to do it.
So, for instance, if you've been pulled over for a DUI, in the past, the officer would ask you to do these tests. Now, what about the test? Can they use that against you if you say no about that?
So that was not handled in this opinion at all. And so part of the decision that made this such black letter law is that the answer, when they ask you whether you're going to take the state-administered breath test, it's after you've already been arrested. You're in handcuffs. So that's what made it extraordinarily clear for the Supreme Court. So before you are arrested, the officer may ask you to step outside your vehicle, may ask you for your driver's license. He may ask to check your eyes. He may ask you to blow into a preliminary breath test machine. He may ask you to do what's called field sobriety evaluations. Usually that involves some walking or holding up your foot. It's not clear right now whether that's all protected. I would argue that it is, and that you are allowed to refuse that. Whether or not that comes into evidence, you should refuse it. But at this point, the Fifth Amendment doesn't magically, in the 16th paragraph of the Georgia Constitution, doesn't magically come into play when the handcuffs go on. But there's different levels of your protection based on how far you are into custody.
So this decision, Kim, only addresses the tests that they ask for after you've already been arrested. So it's not specifically addressing all of the, the walk and turn, stand on your leg. None of that is addressed. So it's just saying that when typically right now at the very end of a DUI investigation, they read from a card.
Right.
And what the court said is what is written in that card is unconstitutional, right?
That's basically, they haven't dealt with the implied consent notice. What they're saying, it's unconstitutional for that refusal to be used. So the card itself, the law, is unconstitutional that you can use it. They're not dealing specifically with the notice, but that's how the prosecutors are interpreting. And I want to be very clear. The Elliott decision only applies to the asking for breath. Believe it or not, the decision for your blood and urine is still up in the air at this point. And that probably is coming down the pike to be decided. There are other cases in the pipeline going up to the Supreme Court. So what is happening is they've been crystal clear about a breath test. When the police, after arrest for DUI, ask you for a breath test and you refuse, that cannot be used against you. So that's what's clear from this opinion.
So we don't know, because sometimes officers will ask for blood or urine, which to me, that seems even more intruding than a sample of your breath. But the court did not directly address those types of tests, even though it's read from the same card.
Right. Well, so in the card, normally the police officer can choose which one they want to ask for. And they can choose more than one. They can ask for your breath or your blood or your urine or all three. But the court only deals with what's specifically in front of it. And the specific question in this one was breath. So those other things are still kind of in the wind, but we would argue as well, like you would, that is an act that cannot be compelled. Because I agree with you. Somebody sticking a needle in your arm or you having to disrobe to pee in a cup is more invasive than blowing in a tube in a breath test.
I've actually had a case where a client, the police officer forgot to turn off the recording, and it was recorded of my client screaming and crying as they were holding him down to take his blood, and it really made me question which country we were in when I was listening to it.
I had a case that I was arguing just last week in Douglas County where the officer pulled a taser on a motorist on the side of the road because she was refusing to do the field sobrieties on the side of the road. When I was questioning during a motion, I said, well, what would happen if she refused to give you blood? And he said, we put her in the restraint chair. And I said, and the taser comes out? And he says, yeah, if I needed to.
Wow.
Like it was nothing.
And, I mean, can't they just get a warrant?
Well, in that case in Douglas County, they did get a warrant. But what I'm saying is, if then the person doesn't want somebody to invade their skin, they can, A, be charged with an additional crime and apparently tasered in Douglas County. But that's what I'm saying. At what point do we invade all of our liberties to feel like we're safe? Because how safe do you feel when you know a police officer can tase you for not doing what he wants?
So this ruling doesn't prohibit the testing of blood, breath, or urine, right?
No.
It just says that if you refuse, which is your legal right, that your refusal cannot be used against you in court. So, like, basically what would happen is when you would go to court and you'd have a trial, the prosecution would argue through the testimony of the police officer and in their closing argument that because you refuse to take a test, and sometimes it's not even like a refusal, it's like, what? I mean, it's very confusing.
Right.
For most people who have never had any interaction with law enforcement, to then be asked, they go through this litany of tests, right, Kim? And then they're asked for another test, and they're like, wait, I already
took
blew.
all your tests, didn't I pass?
Yeah,
yes.
I already blew in the portable breath test. Why do you need me to blow again? And so sometimes in my experience and with the cases I've represented, they don't understand what's going on. It's not really a refusal, it's confusion, and they feel like they're being tricked.
Well, and imagine on the side of the road, typically at night, you've just been placed in handcuffs. Somebody reads you a 20, 30 second announcement and then asks you for a answer. And when you say, wait, can I call somebody? Can I ask for a lawyer? Can I want to ask questions, and they say, no, I need an answer, and you can't have a lawyer. It's a pretty important question, and the police officer sometimes can read it really fast. One time I had a police officer read it so fast, he sounded like an auctioneer.
And what's the importance of what is the importance of not using a person's legal right to refuse a test? What's the importance of not using that against them in court?
Well, because when you have a right not to incriminate yourself, it is not a right if there's no protection of the privilege. If you have a privilege to say no, but the no gets paraded in front of the jury, then it really isn't the protection of that right. You've essentially abdicated it. If I can say, well, you're doing something wrong because you said no, well, then where's your protection?
And isn't it like shifting the burden to this defendant by saying, well, because you didn't do this, you must be hiding something. Why didn't you come forward and prove you're innocent, right? That's what it's saying at the end of the day.
And what's interesting is there was 250 years of Georgia law that basically said, no, we don't use that in front of a jury or a fact finder, except for a DUI. It was this carved out exception that didn't make any sense. And the Georgia Supreme Court brought all that law together, protecting the rights of citizens.
So let's talk about, what about if I have a case pending right now with similar facts to the facts that were addressed in the Elliott case? What does this opinion, what does this ruling do to my case?
Well, so I've talked to some prosecutors and actually some judges. And the interesting part is, nobody is very clear right now what's going to happen, because each prosecutor's office can decide how they're going to handle a case. Like, there may be enough facts without the refusal for the prosecutor's office to still want to prosecute your case. There may not be enough facts, and they may offer something different, or they may reduce your case, and some cases could even be dismissed. It's going to be in the decision of the prosecutors. But I would recommend that if you do have similar facts to that and you have refused, that you do continue to fight your case, because I think it's important. That's how this right got preserved, someone fighting their case, and that's how our rights are preserved.
What about the people who have already been convicted of a DUI under these exact circumstances? What does that do to what does this ruling do to their conviction?
So I think whether they've been convicted after a trial or whether they have pled guilty, and it has to be within the last 12 months, because that's your only window for something called habeas corpus, which is a legal term for produce the body. But essentially you have a limited right of habeas corpus in Georgia for 12 months after a DUI conviction to protest the conviction or try to bring it back. Well, this is a marked change in the law, which I think would give you a basis to file for habeas corpus. So we're actually we don't have that many clients that have actually pled guilty to DUI, but we're going to contact all of our clients within probably about the last 11 and a half months to see if there's something else we can do. Like I said, there still may be enough evidence for someone to be convicted. Driving, odor of alcohol, admission of drinking, doing the fields. There could be enough evidence for a jury to still find you guilty. However, if they don't have the extra evidence of the refusal, would the outcome have been different? And I think everybody can say we don't know the answer to that.
So if you have a DUI that is pending in court right now, you definitely need to reach out to an attorney. Kim Fry is a great one. What's your phone number, Kim?
770-919-9525. You can text us at that number. You can also email us at admin@frylawgroup.com. But just get in touch with us and we can let you know what your rights are and what possibilities you might have.
That's great. And what about, does this ruling apply to, do you think attorneys are going to be arguing that this ruling also applies to the request for blood and urine?
Yes, and I also think we're going to be arguing, because I've already started arguing it and have been, and Greg Willis, my friend's been arguing it for 3 years, that it also applies to the fields before you go into custody. So essentially the preliminary roadside breath test and the field sobriety. So my advice is still the same. You can say no thank you, I'd rather not. You can also say, am I free to leave? The officer's got to answer you, are you under arrest? And then depending on what they say, you can say, can I have an attorney? Those are really the 4 things that you need to say. You do not need to let anyone check your eyes. You don't need to blow in anything on the side of the road. And right now, actually, police officers are being told not to read implied consent, but if they feel like they have enough probable cause to ask for blood.
Well, Kim, I live where I work, where I practice. I'm a mother of 4. Is this ruling just going to turn into drunk drivers driving all over? And, is that the end result of this ruling?
Well, no, but that's what the state of Georgia and the prosecutors claim, that this, they're never going to be able to prosecute a case. But we've prosecuted DUIs long before we ever had testing, and we have prosecuted DUIs when there isn't a test available. The interesting part is it's going to make people make a better case. It's going to make people do their job more appropriately. For a long time, we've sort of let some rights erode because of DUI, but a DUI arrest and conviction can literally ruin someone's life. So you want to make sure that you're doing it right, and you want to make sure that the police are doing their job right instead of sort of, using something that would be easy for them.
So before this ruling, the state was able to say, well, because, perhaps they didn't have enough evidence in and of itself, but because this person refused to give a test of their breath, and like I said, it's not always a refusal, that must mean that there was a presence of alcohol in their system, right?
That's right. That was a jury charge, and I think that would definitely be a charge that is not, it was almost a presumption. That charge would be not in favor. So there's probably a lot of jury charges in DUIs right now that are going to be redrafted and changed. I would also expect the legislature is going to try its hand at fixing this issue that we have right now, but we don't know how they're going to try to fix it, and we've heard maybe Miranda warnings in the implied consent, probably going to take out the punishment portion. We don't know the answer to that. I think the legislature will be in session probably till the end of March, so we won't know until then.
But if you do refuse the test, you still could have your license taken away from you.
Absolutely. There's a civil penalty for not taking the test. And what the implied consent notice also said, which was confusing, is that your license would be taken away from you if you refuse the test, which was not altogether true. Then it also said your license could be taken away from you if you took the test and were over a .08. So at the end of the day, it was basically a notice that, hey, whatever we decide, we're just going to try to take your license. So what I always say to people is, the police officers are going to do what they're going to do. You don't have to help them.
Okay, I think we got some comments. Are you open to taking some?
Sure.
Okay, let's just take a little peek here. We have John Clark. Amen. I wonder if they'll ever address DUI checks. The restraint chair is an issue, in my honest opinion. I think we would agree with you. We have, they're essentially using your rights against you. That's exactly what it is, John. In other words, their incrimination you're trying to avoid happens in the courtroom. That's 100% accurate. I think what the moral of the story is we need to watch this area of the law very closely. I think there's going to be a lot of changes in light of this ruling, a lot of changes that we as defense attorneys have been fighting for and arguing for years. But we were constantly just shut down, and it was, it's incredible that finally
our Supreme Court was brave enough to stand in the face of the state of Georgia and all the prosecutors and the sheriffs and the police officers and say, hey, you know what? We're not going to let you step on these rights. And I think that's going to lead to some better law in a lot of situations, but especially DUI law, because it seemed to be this constitutional exception. And everybody likes to talk about our founding fathers and what they'd say, and we have all these exceptions because of cars. They wouldn't have known about cars, but I don't think they would have been happy if somebody just got to come up to their horse and take all their belongings off of their horse just because the horse could walk away, which is essentially the argument with cars. So I look to also our U.S. Supreme Court narrowing some of these things as well.
Well, I think this is really awesome that the Supreme Court of Georgia is holding up the Georgia Constitution. I am a firm believer in upholding the Constitution, and for years that hasn't happened, so I applaud the Georgia Supreme Court for that. If you are or you know someone who is facing a DUI charge right now, and they need someone to fight for their innocence and to fight for an awesome outcome, they need to call Kim Fry right now and get on her waiting list to meet with her. So thank you guys all for watching, and have a good night.
Good night.